Good evening, everyone, and welcome to the Centre for Environmental Justice's Town Hall event to discuss Part 9 of the Planning and Development Bill 2023. I'm delighted to see such a broad range of groups and individuals in attendance tonight, including community and environmental groups, residents' associations, legal experts, as well as councillors, TDs and senators. We hope that this event will both raise awareness of the implications of Part 9 of the bill and answer any questions you may have about it. For those of you who may not be aware of us or the work that we do, Community Law and Mediation is an independent community law centre and charity, working since 1975 with communities impacted by social exclusion, disadvantage and inequality through the provision of free legal, mediation and education services. In 2021, we opened Ireland's first Centre for Environmental Justice, which works to ensure climate change and other environmental harms do not disproportionately affect marginalised groups, and that the state's response to environmental challenges addresses inequality and protects the rights of present and future generations. In addition to providing free legal, mediation and education services, we also advocate for policy and law reform, and we've been tracking the Planning and Development Bill since it was first drafted in 2019, and have been raising concerns and making submissions on the access to justice aspects of it since then. So why is planning important? Well, it shapes and impacts every aspect of our daily lives, where we live, how we travel to work, and the amenities and services we have nearby. It impacts our physical and mental health, including the air we breathe, the level of traffic and noise in our local area, our exposure to environmental hazards, our access to and connection with the natural environment and light, as well as our own sense of belonging in a community. Planning has a crucial role to play in how we protect the environment and adapt our communities to deal with flooding, heat waves, and other challenges brought on by climate change. Proper planning ensures that the right development happens in the right place at the right time. So in terms of the bill itself, it was published in November 2023. Its purpose is to consolidate all of Ireland's previous planning legislation and make our planning system more streamlined and straightforward. And staggeringly, it's more than 700 pages long. Access to justice via judicial review has been a key point of contention throughout the shaping of the bill. The proposed changes under Part 9 will make it more difficult and potentially costly for citizens, residents' associations and community groups to challenge planning decisions which affect their community and the environment. The focus of tonight's discussion will be on the access to justice provisions contained in Part 9 of the bill, and we have an excellent lineup of speakers to take us through what Part 9 provides and its potential impact, including Gavin Elliott, environmental lawyer at Community Law Mediation, Robin Mandal, Chairperson of the Dublin Democratic Planning Alliance, and Mary Leary, Chairperson of Cork Harbour Alliance for a Safe Environment. We will hear short presentations from each speaker, and there will be some time at the end for questions and answers, so please do pop your questions in the questions and answer box. We will try to keep the time to 1 hour, so we may not get to all questions, and with that in mind, if you see a question similar to one that you'd like to ask, simply upvote the question with the thumbs up function, and that will make the question more likely to be addressed. I just ask you to note that this event is being recorded and will be available to view back on our social media channels at a future date. So let's get started. Our first speaker of the night is Gavin Elliott, environmental lawyer at Community Law Mediation. Gavin is a barrister with extensive experience in private practice, specialising in public interest, civil and regulatory law. Tonight, Gavin will be providing us with an overview of Part 9 of the bill. Thanks, Gavin. Yeah, there you go.
Sorry, apologies for that. Can somebody confirm that you can view that? Perfect. So as Rose said, I'm going to give a very quick overview of the provisions of Part 9 of the Planning and Development Bill. One thing to bear in mind, I suppose, is that the focus today is very much on Part 9 of the bill, which is on access to justice provisions. But there are many other aspects of the bill, and it, as Rose pointed out, it's a very, very long bill. So just because we're focusing on Part 9 and the access to justice aspects of it doesn't mean that that there aren't other aspects of it which are also of concern to us. So, as was said, the bill was published in draft form early last year. That draft bill was subject to pre-legislative scrutiny by the Joint Committee on Housing and Local Government, and heritage. The committee took extensive evidence from stakeholders at meetings during February of last year, and they published their report in April. There was a huge amount of input into and feedback on that draft bill. Then in November of this year, the bill was published and introduced to the Oireachtas and has passed first stage. It's now at the committee stage, which means that the committee will sit again to examine the bill and to publish their report on it. It's expected to become law in some form or other before the summer, although that's not clear, but that's a sort of indicative timeline. And also, just to point out that the indications are that the bill will be commenced, i.e. will become law in stages. So it'll be passed by the Oireachtas, but the minister will have the power to commence certain sections before others. It's 700 pages long with 541 sections and 6 schedules, and making it the third largest piece of legislation in the history of the state. And there's a little quote there from Minister O'Brien. It's designed to become the cornerstone for Irish planning in the coming decades. In effect, this bill will wipe the slate clean and introduce a whole new regime for planning. So this will be the one piece of legislation which will cover most planning matters in Ireland going forward. Part 9 of the bill deals with judicial review, and just to give a little bit of an introduction to judicial review for anybody who's not familiar with it, that's the process by which a group or an individual can challenge a decision of the state and can ask the decision that the state has made using executive power, and can ask the courts to review that. So it's a manner in which an individual can really take something to the courts where their view is that the decision has been made unlawfully and or not in accordance with law. And judicial review is very much a cornerstone of our legal system. It's one of the ways in which citizens can hold government to account, and one of the ways in which we can ensure that decisions which are taken by government are taken correctly. The bill will make substantial changes to judicial review in planning, and judicial review in planning matters is already substantially different from judicial review in other aspects of the law. It's already much more restricted. So, for example, in the timelines that you have to take judicial review, in most circumstances, that will be 3 months. In planning matters, it's 8 weeks. And that's just an example of how the current law already restricts judicial review in planning matters. The bill will restrict it considerably further. And the focus today, this evening, will be on how those restrictions will impact residents' associations and what are known as unincorporated associations and other NGOs in terms of their standing. So Part 9 makes changes to what's known as the standing rules when it comes to who can take a judicial review. The standing rules are essentially what criteria you have to fulfill before you can take a judicial review. And it says that an applicant shall not be regarded as having sufficient interest in the matter in judicial review proceedings, so they won't be able to take a case unless the applicant is or may be directly or indirectly materially affected by the matter. The inclusion of directly or indirectly materially affected by the matter is an addition to the current law where the sufficient interest test is applied. So basically it's adding a little bit of an extra barrier there to accessing judicial review. Importantly, for unincorporated associations, the new bill states that an applicant other than an unincorporated body of persons shall be regarded as having sufficient interest if they have made submissions of a material nature to the relevant body. And in the vast majority of cases, that will be Implore Planola before the relevant body whose decision, act or failure is at issue in the proceeding. So that is essentially a scenario which a lot of people will be familiar with, where you've participated in the planning matter before a decision has been taken by Cork, so where you've submitted observations or that sort of thing. Importantly, the new bill excludes unincorporated bodies from that. So just to focus on those unincorporated bodies for a moment, there's an estimated 17,000 unincorporated bodies functioning in Ireland, and they provide all sorts of services. They range from things like residents associations to sports clubs to tidy towns committees to neighborhood watches, cultural, sporting, social services. All sorts of bodies fall into this category of unincorporated associations. And in essence, an unincorporated association is one where you have a group of people who've come together for a particular purpose, where they don't have or they haven't set themselves up as a company, or having a formal structure and registering with the company's registration office and that sort of thing. So the current law provides that unincorporated associations are able to take judicial reviews. And one of the reasons why it's felt, or at least why a lot of the legal commentary around unincorporated associations would regard them as having the ability to take judicial reviews is, well, first of all, they do quite often, but secondly, so that Ireland is compliant with its international obligations under the Aarhus Convention in particular, but other international obligations as well. The draft bill would require unincorporated associations. This is the draft bill rather than the new bill, but initially when it was published, the draft bill would have prevented unincorporated associations from taking judicial reviews, and the response of the government when that was put to them was that people could take judicial reviews in their own name or as a group of named individuals, rather than as a residents association or other group, or tidy towns group. Serious concerns were raised by that exclusion of community groups by CLM and by others, and many people, including CLM, questioned whether that was in compliance with EU law, and particularly the Aarhus Convention and the provisions of the Aarhus Convention, which requires wide access to justice. So then when the final bill was published in November, that's the bill that's now in the Oireachtas, there was a change to what the government was proposing. The new bill now allows for unincorporated associations to take judicial reviews, but still places restrictions on them. So an unincorporated body shall not be regarded as having sufficient interest unless it has a constitution, holds a vote amongst its members in accordance with that constitution, and is authorized to bring proceedings in relation to whatever is likely to be the subject matter of the judicial review by no less than 2/3 of the members casting votes. And I think this is probably the most controversial aspect of it, and potentially the most chilling aspect of it. If that 2/3 vote is cast in the affirmative, then when an application is made for judicial review, an affidavit listing the total number of members and the names and addresses of all of the members who voted yes will have to be submitted to the court, and that will become a court document, which will be obviously available then to all parties in the proceedings. So I think we can see from what has been proposed in relation to community groups is that there's certainly, I think, unambiguously an attempt to try and restrict these groups from taking judicial review, from an initial proposal in the draft bill to exclude them completely, to now a proposal that they will be restricted and that extra barriers will be placed on them. And some of those barriers certainly arguably could be quite chilling. So one thing the new bill does is it provides a sort of different category for unincorporated bodies such as community groups or residents associations and environmental NGOs. So if the proceedings, so it allows environmental NGOs or ENGOs to take judicial reviews if the proceedings relate to development that's likely to have significant effects on the environment, and says that they will be regarded as having sufficient interest, regardless of whether or not the material affected, if they, and then lists a series of hurdles that environmental NGOs will have to jump. And when we're talking about environmental NGOs here, we're talking most likely about the more established environmental NGOs who are a company who've been around for some time. So they will have to have existed for a period of not less than 1 year prior to the date on which the proceedings were issued. They'll have to be a company incorporated somewhere in the European Union. They'll have to have a constitution that includes an object related to the promotion of environmental protection, which again, for some organizations, might mean that if environmental protection is something that they don't focus on, or something that maybe they've grown into over the years, they might not have. And they must have pursued that object for a period of not less than 1 year prior to the bringing of proceedings. I think very significantly, they will have to have no fewer than 10 members, and that's members in the company law sense of members of the company. The requirement for 10 members there seems relatively arbitrary. And then the board of directors or equivalent governing body will have to have passed a resolution in accordance with its constitution, authorizing the bringing of the proceedings. Given some other changes earlier in the bill in respect of judicial review and the tightening of time limits, that can also be a very difficult thing when you're having to have votes of boards of directors, potentially resolutions and that sort of thing. So, and that relates to environment, to community groups as well, the restriction of timelines, which is shot, the whole section of part 9 is shot through with restrictions on timelines. So that will also have an impact on the ability of people to bring judicial reviews. And lastly, then, just to focus on one other aspect of it, which may be of some relevance, the draft bill contained a very short paragraph suggesting that provision would be made for a new costs regime. So the publication of the bill in November is really the first time we've seen any detail on that. And what is proposed is that the existing rules for costs, and some of you may be familiar with costs in environmental cases, and cost protection and that sort of thing that are there at the moment. But those existing rules were going to be replaced by a new environmental legal costs financial assistance mechanism, which is a bit of a mouthful, but I'm sure it'll become an acronym soon enough. This will allow the minister to set costs award allow the minister to set the costs, the amount of costs that can be awarded by a court in respect to proceedings, and where the applicant succeeds or where the applicant doesn't succeed, they'll be able to apply to this financial assistance mechanism to have their costs paid by that mechanism. An applicant intending to bring proceedings relating to the environment may submit a financial resources and eligibility statement prior to the bringing of the proceedings, or even during the proceedings. And those statements then will be used by the body administering these rules to determine, based on financial resources, whether the applicant is entitled to some, none, or part of their costs. One of the major criticisms that has emerged of this new cost regime is that, well, there's a number, but the main one, I suppose, is that the costs will be set by the minister. So the fear is that they'll be set on a scale akin to the current legal aid scheme, which doesn't really pay a great deal, particularly doesn't pay a great deal in terms of legal costs. So it could act as a disincentive for lawyers to act in this area. And certainly it will be something that impacts quite strongly on the current system, where there's environmental cases are very often taken on a no-fault, no-fee basis, where lawyers, solicitors, and barristers will agree that they won't seek their costs from their client if their client loses. So that's just a very, very quick run through of the new provisions, and focusing particularly on the impact on groups, community groups, and NGOs. And I will leave it there. But of course, if there's any questions, I'm more than happy to answer them at the end.
Thanks so much, Gavin. That was a really clear overview of those Part 9 provisions. And I think some of the really interesting changes you talked about, and kind of scary changes in a way that you talked about, in particular, that requirement on unincorporated associations to, once they pass the resolution, the 2/3 vote on taking an action, the fact that there's now a requirement to have an affidavit setting out the names and addresses of not all of the members of the residents association, but just those who have voted. And you'd wonder what the rationale is for that.
Just as put it, yes. So you could have been at the meeting, vote no, and then you don't have to have your name submitted. But if you vote yes, you do. So it's I can't understand the rationale for it at all, other than potentially.
And even some of the other provisions, for NGOs having to have a member, as you say, in the company law sense of the word, which is different to normal membership, of 10, it's just a kind of a random number, and this requirement to pass a board resolution already within a really tight time frame. It just seems to be creating these unnecessarily blocks and barriers. So thanks for that overview. And I already see lots of questions in the Q&A box, which is fantastic, and hopefully we'll get time to answer quite a few of them at the end. But I'm going to move on to our second speaker, Robin Mandal. Robin is the founder and chairperson of the Dublin Democratic Planning Alliance, a voluntary organisation and alliance that represents over 72 resident associations across Dublin. The Dublin Democratic Planning Alliance campaigns for the needs of the citizen and the community in the growth of livable neighbourhoods in Dublin. And tonight, Robin will be discussing the impact the proposed changes under Part 9 will have on residents association and concerned citizens alike. Thank you, Robin.
Thank you. Thank you very much, Rose. I'll just share my screen now. Okay. And I will set my timer. So just bear with me. Right. Okay. Right. So I'm going to just give a sort of a brief overview of how this is going to affect primarily resident associations. Now, the DDPA is much bigger than just resident associations, but I'll focus just on how this impacts on resident associations and on the bigger picture of how it's impacting on public participation generally. So this is just an overall of how did we get to this bill, the 2023 bill? And it's right back from the beginning. I don't know if you can see the 63 Act. And the interesting thing about the first two is that they were called the Local Government Planning and Development Act. Disappeared in 2000, in fact, in 1999. These are all the things that happened to get us where we are. When ours was ratified, Section 50 was altered, and that has worked in my view very well. And that's the bit that is really being changed radically by Part 9. I've just put in the other sort of 4 items above the general scheme of the original JR bill, which was 2019, died without trace. And they were the things that really caused this whole explosion of judicial review, as far as we see it. So the first one was the 2015 Act, which introduced Section 28(1)(c), mandatory rules that overruled the local development plans. And that then led on to a number of very problematic Section 28 mandatory demands, which led to a string, really led to most of the judicial reviews, because it ended up giving an awful lot of material contraventions to development plans. The 2016 Act was the SHD one, which again was a trigger because the planning was falling apart because of these interferences in what was the 2000 Act. That really started the spate of judicial reviews that we now see. And at the CIF annual conference in October 2019, the then and now Taoiseach gave a speech saying he would be addressing this. And shortly afterwards, in fact, the 2019 bill had just been published, so he was floating it as the solution to the spate of judicial review. And from where we stand, that spate had nothing to do with planning. It had to do with the way the planning system had been interfered with by lobbyists, effectively. So in that 2019 one, which then disappeared for a while because of COVID primarily, those 5 things would change, and 6 things would change. So there was this issue of correction of errors. There was ex parte being replaced by on motion. There was changes to substantial grounds, changes to sufficient interest and standing rights and costs. And those last few have found their way into the current draft, the 23 Act, the 23 bill. The 22 bill had various different bits. And then I said I would just have a quick look at other factors that are affecting participation. And on the left here, you have an editorial from last week of the Irish Times, where our problems, the first is planning. And then this underlines exactly what this bill is doing. All might gain from less devolution of planning, right? That's what this bill is doing. It's centralizing planning, reducing the need to allow third parties participate in the planning process. That's exactly what this bill is doing. And then the planning, they refer to the bill going through, which limits the grounds for judicial reviews, among other measures. So it's there in black and white. That is the 3 thrusts of this bill are in that editorial. So just going to ones that aren't in part 9, and I'll get to part 9 very, very quickly now. Public participation has been reduced because third parties now cannot seek declarations in exempted development. There's no justification for removing that right. The only people who can is a developer or the owner of the land. The national planning policies and measures are a replacement to the problematic Section 28 bits. So they are gathering all the power to the minister. And the big fear is that we've seen how lobbying has affected the ministerial powers. This is just railroading that right into the system for the foreseeable future. The role of the Office of the Planning Regulator is also very difficult in this bill. I mean, the role has expanded quite considerably, and effectively, even though it's stated as being independent, as the Commission will be, it has to do what the Minister of the day says. It has to enforce those national planning policies and measures. That's a worry. And then these 3 are so at local planning authority level, there isn't any specific rules as to who can and cannot make observations. In the earlier draft, to make an appeal to the Planning Appeals Board, there were exclusionary factors in there for resident associations. You didn't have the standing to even make a submission analysis of the bits of the bill that have been of concern to DDPA, and I won't go through them, but I will just go through my notes. So the first one is the judicial review on motion rather than ex parte will make it very, very complex and add to the costs very early on. The time limits should be from when the applicant was informed of the decision, not when the decision was made. There are clauses for striking out. That's 255. Strike out the courts can do anyway. There's no need for that. You know, if the court decides that the application isn't going to work, they will strike it out. The stays are okay. The sufficient interest ones, I'll do very briefly. And the appeals to the Supreme Court, I'm not so sure that is I think that will probably be challenged. And then the amendments and that the Commission can make are really problematic because they open up a complete sort of festival of what can and can't be done. And then the whole issue of costs is quite sinister in that costs, it isn't clear from this whether anyone taking a judicial review, it says costs can be awarded to any party. So it isn't, the cost protection may be exactly the opposite of what, at least the cost scheme may be the exact opposite of a cost protection scheme. I've just left this one in here just to add to Gavin's note about how this is going to impact on resident associations. The bit that wasn't on Gavin's slide was the top one, which is that it has to be a partnership within the meaning of the Partnership Act. It has to be a limited partnership and it has to be able to sue and be sued. Now, I don't know of any resident association that is a partnership. People, there are a lot of lawyers here. People go into partnerships very, very carefully. I think it's absolutely unworkable that a resident association could be a partnership. And the fact that they have to be able to be sued is quite chilling. And then I'll finish off on the last bit about the names and addresses. It's completely unjust that the only people who cannot be anonymous are the people who vote in a residents association. A company can apply for the planning application. Everybody else in the whole thing can stand behind a chairman or a representative or something. They can be anonymous. But certainly I know that in any cases that I know of, if the people who voted for a judicial review knew that their names are going to be published, they would not vote for it. It's simply intimidation. And that's the long and the short of it. So that's really all I have to say. Very, very willing to answer any questions. Yeah, I just put this in always at the end because this is the sort of thing we're railroading into our cities, and without a by your leave. So thank you very much. And let me stop the share. Oops. Right.
Thanks so much, Robin, for that. And really interesting perspective there. And, I'm particularly struck by your reference to some of the narrative around this and the narrative leading up to what was originally the Housing and Planning and Development Bill and now the Planning and Development Bill, this kind of need to find a solution to the spate and the tsunami of judicial reviews without looking behind why some of those judicial reviews happened in the first place. The fact that first of all, most decisions aren't reviewed. Like it's only a tiny, tiny percentage of decisions that are reviewed. And secondly, that bit of an increase that there has been, a lot of that related to SHDs. And because those SHDs bypassed the kind of democratic process, and the only way you could appeal it was to go through judicial review. And an interesting report last week by a construction body talking about how since the introduction of the large-scale residential developments, they are moving along much more smoothly because it's reintroduced this kind of two-stage process. So there's kind of this narrative about the tsunami of judicial reviews without looking behind, what are the actual figures, what are the reasons behind those judicial reviews, and ignoring the fact that actually, remember, the vast majority of those JRs are successful. And the only way you're successful if there's been some sort of a breach in the law, a breach in process. So it's just interesting the way the narrative has been shaped on this, and unfortunate the way the narrative has been shaped on this. I'm going to move to our final speaker. We're delighted to have with us Mary O'Leary, the chairperson of Cork Harbour Alliance for a Safe Environment, CHASE. CHASE is an alliance of local groups campaigning since 2001 to stop the construction of a large 240,000-tonne commercial incinerator in Cork Harbour. Tonight, Mary will be speaking about the impact of Part 9 on the ability of organisations like CHASE to hold state, corporate bodies and others to account in relation to breaches of environment and climate obligations. You're very welcome, Mary. Thanks very much.
Thanks very much. I'm coming to this, actually, and I'm not a legal person. My background is in environmental science, so I'm just commenting it I'm commenting on it from that point of view. And I suppose from our own experience over the last 22 years or so. Many of the points that both Robin and Gavin brought up are similar to, I did read the 700 pages of the bill. I ploughed through it in my own way, and many of the points were the same. The only good news that was in it was that they didn't change. Initially there was talk about changing the 8 weeks to 4 weeks, which would have been absolutely impossible. So that was dropped at least, that's small mercies. But the whole point about communities, I mean, communities or any kind of a group, they don't take judicial reviews lightly. They take it because there is something, as you just said, Rose, it's a flawed application and it's taken on a point of law, not another other issue. So, I mean, the way that this new bill is being structured is designed, as we see it, to deliberately intimidate communities in every way possible. As I think it was Gavin said, I mean, even the thing about taking names and addresses of those who vote in favour of seeking judicial review, that's nothing short of intimidation, because most people's experiences of the law are generally making a will or something. People don't engage with the courts or the law lightly because it's a terrifying place and terrifying costs and all that. So, I mean, that's really worrying in terms of how undemocratic it is in terms of who will qualify. I mean, Chase wouldn't qualify under this new bill. We wouldn't be able to take any of our proceedings, even though we're still fighting the application, we have been vindicated in many ways through the various processes we've been through in the High Court, in terms of challenging the planning applications when we did. And again, I suppose the other thing is also worrying is that the minister will prescribe the monetary amounts that will be allocated. The minister is not an independent person; he's politically appointed. And he, as a minister, his job is, or whoever the relevant person is that he appoints to oversee this, their job is to save costs. And as Gavin says, I mean, that kind of for us takes away the people's existing rights to recover legal costs. And also it takes away the right to employ highly qualified legal representatives because it's a specialized area. Planning is very specialized and it requires that level to be anyway successful. So by imposing financial restrictions on who you can have, because I think in section in section 267 267D, 267D, it says the categories that the minister will decide on, the categories of legal practitioners who may participate. So again, I would see that as restricting the level of legal legal people you can employ, and it takes away also he decides also who can take the appeal at the initial, as I understand it. He will decide on whether they have sufficient interest. Now, again, it's not up to the minister, as we would say it, to decide that. It is up to the court. So when you go to the court for judicial review, you go on points of law. And as I see it now, if the minister decides at the very beginning whether, as a group, you can take a judicial review, then I think that's interference with the courts, and it's not an independent process, as we would have had faith in the courts up to now. That when you go to the court, you go there and you argue your points and you get your judicial review, or you don't. If the minister now decides at an earlier stage whether or not you qualify even to seek judicial review, then we see that as being totally undemocratic. And I mean, the legal practitioner, 274, says the legal practitioner must be willing to charge the fees in accordance with the monetary amount under the PDA 2023. So, I mean, I think this bill is, totally undemocratic. What I was slightly, I suppose, annoyed with last week or disappointed in, I heard an MEP saying, well, if it's in contravention of the Aarhus Convention, it'll be challenged when it's passed as a bill. And they said it will be challenged because it's in terms of our ability to seek judicial review under fair and equitable conditions in terms of cost and prohibitive costs. So I think it's terrible that MEPs are even happy to say, well, it's okay, look, you can challenge once it's passed, you can challenge it under the Irish Convention. I would have liked to have thought that the Irish government or our people who set our bills would actually take that into consideration before they even pass the bill, because challenges cost money, and we end up often with Ireland being one of the offenders in terms of environmental law, paying huge fines because they've breached European directives. So, and they breach European law. So, I think it's not a great reflection on our government in a way that they're happy to proceed with a bill that probably will be challenged and will be challenged under the Aarhus Convention, I think, once it's passed.
I think you're muted there.
Sorry, I
Yeah.
should know that by now that you need to turn the unmute button off. But really interesting, Mary, to hear you say that under the current proposals, Chase wouldn't qualify.
No.
And there's lots of organisations like Chase who I'm sure would find themselves in a similar boat. And also what you're saying in terms of, and I know Gavin made this point too, the amount of lawyers that will be available to take cases for
Yeah.
NGOs, for residents groups, will dramatically shrink. For
Sure.
obvious reasons. I mean, the kind of system of no full, no fee kind of acts as a filter in a way, because the way that's structured is a lawyer won't take on an unmeritorious case. They won't take on a hopeless case because they've no chance of getting their fees. But it allows meritorious cases to go through and be heard and to have poor decisions rightly challenged. But this new structure will really reduce the amount of lawyers that will be available to do work in this area. And that other point about the challenge, a potential challenge in relation to our house or other things. I mean, there's been a lot of commentators on all sides of the equation that have commented that actually what has become kind of a settled area of law around costs and other matters will now be thrown up in the air and will be open to challenge and will lead to huge legal uncertainty and lots of challenge and delay on what might be actually important projects. Remember as well, that can happen too. And that's not in anyone's interest. It's not in anyone's interest that we have further delay, when actually the intention is, in theory, to streamline the process. But thank you so much for that, Mary. That was a really, really interesting overview from it, from the point of view of an NGO. And I suppose we've heard now what Part 9 proposes and how it will impact on concerned citizens, on residents associations and environmental organisations, all of whom play a vital role in making neighbourhoods a better place to live and in protecting the environment. And remember, we are in a Dáil declared climate and biodiversity emergency, and never has it been more important to ensure that government, the construction industry, corporate bodies and others are held to account in relation to breaches of environmental and climate obligations. So the question now, coming up to 8:20 is what can all of you do? What can people who are listening do? Well, as Gavin pointed out, the draft bill has undergone pre-legislative scrutiny last year, and the bill itself was published in November. And so it's introduced by the Oireachtas, past the first stage, and it's now moving to the third stage, the committee stage, where detailed examination and amendments are made. And this is likely to commence next week, February 12th, and the government aims to pass the bill before the summer. So things are moving along, but it's not over yet, and there are still things you can do. So it's not too late to voice your concerns. And you can do that by contacting your local TDs, by contacting the Minister for Housing. And what we have done, and I think we've just put in the chat box, and it's also available on our website, is we provided a useful email template. It's in the link, it's on our website, which will help you voice your concerns. And this link also provides a useful resource to finding the relevant TDs in your constituency. Now, obviously, this is a template, so edit, add to it as you see fit, emphasize maybe issues that are specific to your own locality or environment, but that is there, and hopefully will be a resource to you in making your own concerns heard on this. But I'm conscious we have, which is absolutely fantastic, loads of questions in the Q&A box, and we have a short period of time within which to address them. So I'm going to go to them in turn. Let me just see if there's any kind of order of priority. I'll just go to the first one. How will the bill's cost provisions change the position of a person or group who lose a judicial review? So Gavin, I might come to you with this one. So, you might just give a very brief answer as to how does it work now if somebody loses an environmental case, and how will it work under the bill?
So the current system for cost protection in environmental matters says it goes back to what you said a moment ago, Rose, in terms of the cost regime is now kind of settled after a long period where it was very unclear who was entitled to what and what certain provisions meant and that sort of thing. But very basically, if you, as the law currently stands, if you win the case, you get your costs. If you lose the case, then you're entitled to, you're likely to take it at no full, no fee, and there's an element of cost protection in there. It's all quite complicated, so I don't want to get into the details. But the new provisions set out a whole new regime. So it means that both the winning party will get their costs paid by the other side, the losing party will have their costs paid by this new cost mechanism. The costs for both of those will be set by the minister. You will have to apply to this cost mechanism to, prior to the taking of proceedings to see whether or not you qualify. There's an eligibility criteria. There's financial criteria as well. It's very unclear how a financial test, which seems to be a sort of, but by implication, you set out your assets, and the cost mechanism, whoever's running it, determines how much you're entitled to on the basis of that. It doesn't seem very clear how that would relate to a lot of NGOs, let alone residents associations. How do you put together a means test, a financial means test for a resident association which doesn't have funds usually? And then there's a whole criteria set out. The minister sets those fees, but then those are the fees that the lawyers will get, but also there's an eligibility criteria, as Mary said, in terms of whether or not you're entitled to anything at all, or whether you qualify for the scheme. And those are a little bit difficult to work out exactly how they're going to work, but certainly the things that are taken into account by whoever's running that scheme will be things like, would a prudent person have taken this case? Would a prudent lawyer have acted in this case? All very subjective tests, which in of themselves are things I think will probably end up being challenged, because you will probably see challenges on the basis of people being rejected from the cost protection scheme because there is a subjective element there in whether or not they're eligible or not. So we don't really have all of the answers we'd want on how the costs scheme will work, but what's there is certainly troubling at the moment.
Thanks, Gavin. I'm just going to motor through some of the questions. So some of the questions I think possibly have been answered just through the presentations. And just to say that this recording will be available after the webinar finishes. I have a question here on what has the international reaction to the proposed bill from environmental groups and public participation organisations been? So has there been any international reaction to this? Do any of the panelists want to answer that question?
I might, if I may. Gavin probably knows much more about this than I do, but the short answer from where I'm seeing it is that there's very little reaction, and primarily because the reaction that we would expect would be EU reaction. And other than Malta, we are now the only common law jurisdiction. So the difference between the Napoleonic codes and ours, they don't get what this means in terms of the way our system works. So to them, the cost provisions are a very positive thing, and they think, yeah, that's it, that'll cover it. They don't really understand how that sort of works. So it's in a way, if they were reading the explanatory memorandum, the explanatory memorandum, they'd see it all rosy. It'll all be nice and everything seems to work. The reality of it is that it isn't. There's an awful lot in it that isn't going to work. I mean, the whole cost thing, and again, I'll stop now, but the whole cost thing, if it's means tested, which presumably it will have to be, and they're just bringing in the Legal Services Regulation Act, amending it, right? So it's a tried and tested. But if it's means tested, the sad reality of it is that people who would qualify for a means test generally would not be interested in taking a judicial review. So if it's means tested, it will certainly kill off anybody with any, with any real ability to take the judicial review. I'll stop there.
Thanks, Robin. Thanks for that. I have a question here. Oh, sorry.
Sorry, could I just say a word there? Actually,
Sure.
We actually have a complaint gone to the Petitions Committee, and it's been passed on to the courts in the European Court. But I mean, it's going to take time to go through it, and we'll have to send in an amendment now because the bill, has changed again. But it's just to say that that's in the ether somewhere, but it could take a long time to get through.
Thanks, Mary. I have a question here. What can we do? What can we do? And I suppose one of the things that we suggest is contact your local TDs. There's still time for amendments to be suggested to the bill, and to make it very clear that people care, communities care, and this is something that we don't want to go through without the changes we're talking about. But there's a second add-on to that question is whether this is going to be challenged in the future. And now my sense is it probably will be, but do the panel have any sense of that if this passes through unchanged, if it passes through in its current form, is there any sense as to whether this might end up in lengthy challenges?
I think it absolutely, definitely will. I think the chances of there not being a decade of challenges to the bill are almost zero. And this is a point I think that has been made publicly by some of the construction industry figures who have sort of indicated that one of their major concerns is that they have a system now which they're not desperately happy with, but at least it's semi-settled and they know roughly where they stand. Whereas this new bill will, throw everything in the air, and it'll take many years for it to settle again. And from their point of view, maybe an imperfect system where they kind of know what they're doing and kind of know where they stand is better than a better system, which is, going to be subject to challenges not only domestically but then Europe as well.
Thanks, Gavin. A question for you, Mary. If the bill goes through unchanged, what will happen to Chase and organisations like Chase?
Well, as far as I know, Chase, because we're already in the process, we're in there. So our case is still live effectively. It's gone back to on board Planola. So from that point of view, as long as it's a live case, I presume we're okay. But if we had to start again into the future, we wouldn't qualify. So we wouldn't be able to, as a community, we wouldn't be able to challenge something that we feel is, not the right either technology or the right area, or there's a whole load of reasons why we've objected to this, and we just wouldn't be able to take the challenge because, as you say, we don't. No community has hundreds of thousands of euros stacked away in an account to take a judicial review. It's when you we do it through fundraising and it's hard earned, so it's a very difficult decision for a community to take to challenge anyway. But if there's no possibility of getting financial relief at the end of it all, I don't know what it's just going to disempower communities.
And a related question, I think, Mary, is if it disempowers communities, and for you too, Robin, if it disempowers communities and community groups and NGOs, what will the impact be for, environmental accountability, for environmental protection?
That's the worry. We don't, that's why communities know what's best for their area. Well, they don't know what's best, but they do so because they care. Communities take challenges normally. They're not being frivolous. They do it because they have genuine concerns, and that's why they take the case. If they can't do it, who's going to protect them? Good question.
I'll sort of add to that the people in communities do have an understanding of the places that they're in. They have an understanding of how it all works. They're the ones who are best able to actually assess what is being proposed, and in the absence, and there isn't generally an absence. So the planners are generally very good, but in the absence of not having very, very high quality planning, they're the only ones really who can address those issues that are being ignored at a national level. I don't want to over-egg this, but when people lose faith in their power as citizens, it leads to very poor outcomes inevitably. So I'd be really concerned about the alienation that this sort of stuff might cause. You don't have to go too far to see the impacts. So that's
Final question for everybody, because I'm conscious of time. So we have, a good group of people listening to this webinar, and we've made available a template, obviously, if people want to contact their local TDs. But there are so many people and communities that really care about local planning that aren't really aware of how the bill is going to impact on them and on their local communities. So what can those listening today do to spread the word and to empower their communities around this issue? Gavin?
I think, I mean, contacting decision makers, contacting, local councillors and TDs, I think is probably the way to impact the bill at this stage. It's in the Oireachtas, so it's going through that process. But I think there's a strong danger of it passing through the Oireachtas without being very controversial, unfortunately. And it should be a little bit controversial. So I think the way to achieve that is to make some noise about it, and to let the government know that there are concerns out there, and that disempowering local communities isn't necessarily the best way to get re-elected.
Thanks, Gavin. And we're going to wrap up. And before we finish, first of all, I'd like to say a huge thank you to our panelists for such fantastic presentations and overview with what is relatively dry and relatively complicated bill, but a very important one nonetheless. I'd like to thank, obviously, you all for attending on a Tuesday evening and for being so engaged with the questions. To keep updated on the bill going forward or on our work in the Centre for Environmental Justice, you can sign up for our monthly newsletter, and the link for that is in the chat box. But also just to say to anybody who's listening who has an environmental query, whether you're an individual or part of a group or an NGO, you can make contact with our service. We do run monthly legal advice clinics, free legal advice clinics, so you can make an appointment with our service. So I'm going to end it there and say a very big thank you and have a lovely evening. Take care.